Hello, and happy 4th of July weekend. My name is Genaro Cortez. I'm a San Antonio criminal defense attorney, and today I want to talk to you about the federal felon in possession of a firearm law. Specifically, I want to answer the four most common questions I get from clients. They are, how does 922G1 work exactly? Second, what does it mean to be in possession of a firearm? In other words, how do I know if I'm in possession of a firearm? Third, how much jail time can you get for a federal felon in possession of a firearm conviction? And finally, I want to talk to you about possible defenses. On top of that, Texas has their own law, a felon in possession law. It's found in Texas Penal Code 46.04. And what's really interesting about the Texas law, it's pretty identical or similar to the federal law. And as we go through this video, I'm going to show you how they're similar and how they're different. So if you have either a federal felon in possession gun crime pending or at the state level, this video should give you some helpful information. 18 U.S.C. section 922G1 has certain elements or facts the government must prove so they can convict a person of being a federal felon in possession. And those facts are: 1, that a defendant was previously convicted of a felony; 2, that he knowingly possessed a firearm; and 3, that the firearm traveled in or affected interstate commerce. Those are the 3 facts or elements that the government must prove to find somebody guilty of being a felon in possession. Now, the possession element is the one that we fight over the most in these kind of cases. I'm going to put that over to the side for a second. I want to focus on the first and third elements first, because those are the easier topics to walk through. Now, the first part is you have to be a convicted felon. And a felony conviction means any crime punishable by a term of imprisonment exceeding 1 year. Examples of being a felon include being convicted of being in possession of less than a gram of cocaine, being convicted of a DWI third, and then the more obvious cases like aggravated assault with a deadly weapon, or robbery, or a drug trafficking crime. If you have those types of convictions on your record, then you're probably a felon, and you're not allowed to own a gun under 922G1 or possess it. Now, the third element is affected interstate commerce, or traveled in or affected interstate commerce. That's actually not a hard element for the government to prove. And here's how I've seen them in trial. The federal prosecutors will call in an ATF agent. That ATF agent will have got the serial number and the make and model of the gun, and they can trace where the gun was made. And so, for example, with the serial number, they'll be able to show that the gun was made in South Carolina or Michigan. So if you're in Texas, charged with a federal felon in possession law, then obviously the gun traveled in interstate commerce from South Carolina or Michigan to Texas, or it affected interstate commerce. That's not a hard element to prove. So now that we know how the first and third elements work, let's talk about possession, because that's really the big issue, and one of the big issues in felon in possession cases. Now, there's 2 different ways to be in possession of a firearm. You can have actual possession or constructive possession. Now, I'm going to read you the legal definitions, and then I'm going to show you how they work in the real world. But there's 2 key facts to possession. But the government has to show that the defendant has knowledge. In other words, he's aware that there's a gun present, and he has control, either directly or indirectly, over the gun. If the government can show those 2 key facts, then they'll be able to show that you're in possession of a firearm. Conversely, if they can't prove that, then they're going to have trouble connecting you to the gun, either showing that you intended to control the gun and or that you actually controlled the gun. So let's go into the definitions. Actual possession. A person is in actual possession if he knowingly has direct physical control over a thing at a given time. That's actual possession. So there's a picture in the background now of a statue in front of the Alamo. I'm not sure if that's Davy Crockett or Sam Houston or one of the people that fought and died in the Alamo, but he's holding that musket or that rifle. So he's in possession of the rifle, he's got actual control over it, and he presumably knows that it's a rifle. So that's actual possession. That's the simplest way to show possession. Now let's talk about constructive possession. Constructive possession. A person is in constructive possession if, even though he doesn't have actual possession, nonetheless knowingly has both the power and the intention at a given time to exercise dominion or control over a thing, either directly, through another person, or persons. For example, police don't find the gun on you, but they find it in a car that you own, and nobody else has access to it. Then you have control over the car, and thereby you have constructive possession of the gun. Likewise, if police do a search warrant on your house, and you're the only person that lives there, in your house or the apartment, and they find the gun in your bedroom, then you're in constructive possession. You don't have actual possession of the gun, but you control the premises where the gun is found, and presumably you know that the gun is there. So that's how constructive and actual possession work. Now, there's one more thing we need to talk about when it comes to possession. That's joint possession or sole possession. It's kind of like child custody. Joint and sole possession of a firearm is basically the same idea. It's the idea that more than one person can be in possession of a gun, and they can be if they're all felons, and they can be charged with being a felon in possession if they know about the gun and they have control over the gun. Now that we know how 922G1 works, we can talk about the jail time. 18 U.S.C. section 922G1 carries up to 10 years in jail and up to a $250,000 fine for people convicted of being a federal felon in possession of a firearm. But what catches a lot of people off guard in some cases is that 922G1 is a gateway crime. And by that I mean, if you have serious criminal history, for example, if you have 3 convictions of either a serious drug case, a violent felony, or both, and you had those 3 convictions before you were charged with a 922G1 crime, then the Armed Career Criminal Act kicks in, and that can really bump up your jail time. So instead of looking at 0 to 10 years in prison, you're looking at a minimum of 15 years in prison and up to life in jail. So if you have a lot of criminal history, the bottom line is you're going to want to talk to your lawyer and see if the ACCA applies in your case. Now, the United States Sentencing Commission keeps a lot of information or data. One of the questions people ask me is, how much jail time will I get? I can't tell you. No criminal defense attorney can tell you. In fact, when you go to court and you plead out, if you plead out, then the judge will specifically tell you nobody can promise you or give you or tell you how much jail time you're going to get. Nobody will know until you go to court for sentencing, and that's the judge will make that decision. He or she will make that decision based on a lot of factors, including the sentencing guidelines and the 3553A factors, the Booker factors. But with that said, the United States Sentencing Commission keeps a lot of data on these types of cases, and they track the average jail time on felon in possession cases. And for a pure 922G1 case, the average jail term is about 5 years, between 55 months to 60 months. I wrote a blog post about this, and in that blog post, I cite the averages from 2016 to 2020. It goes up or down a few months, but that's kind of where you're at. A couple more points. Gun cases are kind of hard because those guidelines are not easy to read. It's more likely to be errors on a gun case than any other type of case that I've seen. And the reason is because those guidelines are not well written. They're vague, they're ambiguous, and it's sometimes not clear if certain guidelines apply or not. So if you have a gun case, you need to review those guidelines carefully with your lawyer. In fact, what I started doing is I've hired a PSR consultant, a lady that I work with who is a retired probation officer, and she knows what the common mistakes are. And if you have a gun case, it may be worth you and your lawyer talking to a consultant to get like a second opinion on the guidelines to make sure they were correctly calculated. Now, the Texas felon in possession is 46.04, as I mentioned before. And on that one, the jail time for that is a minimum of 2 years and up to 10 years in jail. It's a third-degree felony and also carries a fine of up to $10,000. Also, the Armed Career Criminal Act does not apply to the Texas felon in possession law. It only applies at the federal level. However, state prosecutors can use something called enhancements. If you have serious criminal history, they can file notice of enhancements where instead of being a third degree, they can bump you up to a second degree where you're looking at between 2 and 20 years in jail. Or if your criminal history is really bad, they can bump you up to a first degree where you're looking at a minimum of 5 years and up to either 99 years or life in prison. So the systems are different, but the idea is the same. If you're a felon, you can't possess a firearm, and if you do, you're looking at a high risk of jail time. So just be careful with these types of cases. Here are the elements to the arrest offense. That the defendant was in imminent threat of death or serious bodily injury. 2, that he didn't recklessly or negligently put himself in a situation where you would have to possess a firearm. 3, he had no choice. Either grab the gun or something bad would happen to him or somebody else. 4th, there was a causal connection between possessing the gun and the harm or danger that he was facing. And 5, as soon as that danger is over, the person must put the gun down or stop being in possession of it. And it's a narrow defense because it only applies in very limited circumstances. And I'm going to show you how that works. For example, let's say you did a few years in prison for a drug case or something, and it was a felony. You get out and you're living your life, you're minding your business. You got a job, so you go to the bank and you're going to cash your check. While you're in the bank robbers come in, and you, because you don't want to get shot, you disarm the robbers. And if during that process you grab the gun from the robber, then you can raise a duress offense, right? So you can grab the gun, take it away from him, disarm the robber, and then as soon as the danger's over, you can put the gun down. So it only applies in very limited circumstances like that. But that's kind of the ins and outs of how the federal felon in possession law works, and also how the Texas felon in possession law works. They're pretty similar in the key respects. You have to be a felon, and you have to knowingly possess a firearm. Second, the federal charge carries between 0 and 10 years in prison. The state charge carries between 2 and 10 years in prison. So the punishment ranges are pretty similar. However, in the federal system, you may be subject to the ACCA if you have a really bad criminal history. Likewise, in state court, you can get enhanced if you have bad criminal history. But the key point is the ACCA doesn't apply to state felon in possession charges. Also, there's a bit of a conflict between those two laws, and it works like this. Texas has a 5-year gap, or a 5-year window. If you're a felon, you can't possess a gun for 5 years after you were convicted, sent to jail, and completed your parole, or after you completed your probation. After those 5 years, though, there's like a limited window under Texas law that lets a person keep a gun in the home. However, that exception doesn't apply to the federal law. So it creates a possibility where you can follow the Texas law but still be charged with a federal law. For example, if police do a search warrant on your house 5 years after you completed your prison term or your felony conviction sentence, then you may be good on a Texas law, but you can still be charged with felon in possession in federal law under 922G1. So those are the kind of nuances you got to be careful with if you're a felon and you're thinking about owning or buying a gun. If that's your situation, I recommend you talk to a lawyer before you make that decision. It can save you a world of trouble and a large legal headache with these types of cases. Now, I hope this video was helpful. If it is, don't forget to click the like link below and subscribe to our channel. Also, if you have any questions about this video or suggestions about future topics, shoot me an email at info@cortezdefense.com. I love hearing from y'all, and I enjoy listening to the questions. It helps me think about other future topics as well. So shoot me an email, and I'll respond as soon as I get it. Finally, thank you for listening. I hope you guys are having a happy and fun 4th of July weekend. Thank you.